on that regard. Karen, I might pass you over to make some introductions there.
Okay, thanks so much for that, Andy. I'm really excited to be able to welcome Anika and Dean. I'll just give you a brief introduction, a bit of a bio on them so you understand who you're hearing from. Anika is a commercial law and litigation principal at WMD Law. She has extensive experience representing employers and employees across a wide range of industries. She provides them with employment law advice and absent employment disputes. Dean, Groundwater is the head of the commercial group here at WMD Law and has been recognised by the Law Society of New South Wales as a specialist in commercial litigation. Through his 25 years of practice as a lawyer, he has guided companies and businesses through a number of changes in industrial and labour law. So I think we're really lucky to have them both here today to share their knowledge and expertise with us. So thanks, guys.
Thanks, Karen.
Over to you.
I'll just share my screen with everyone now so we can start. Great. So hopefully everyone can see the slides. I'm really delighted to be here to present to you this webinar on the Fair Work legislation amendment, Secure Jobs, Better Pay Act. These are some of the most extensive and interesting changes that have been made to the Fair Work Act in its 13-year history. The Labor government really has wasted no time in furthering its objectives of trying to improve job security, promote gender equality, and support wage growth. So what we want to achieve today is to give our listeners an opportunity to familiarise themselves with some of the changes that have been introduced in the Act, and also enable employers to consider the strategies that they need to adopt at an operational level to effectively respond to the changes. So the topics that we'll be talking today are pay secrecy, fixed-term employment contracts, the enterprise bargaining framework. We'll talk about flexible work requests and requests for extended unpaid parental leave, and we'll talk about sexual harassment in the workplace. These are some of the main changes to the Act that we think employers need to take action either immediately or over the coming year to make sure that they stay compliant and respond to these changes that have now been introduced. So as I go through today, Dean and I will be having a discussion about these changes. And if any of our listeners want to ask any questions, feel free to do so. We'll try to answer some questions either at the end of each segment and also at the end of the webinar today. We've also got one of our other principals online as well, Matthew Coulter. He's behind the scenes and he'll also help to answer any questions that we're not able to talk about on screen. So feel free to send them through. So the first change that I wanted to talk about today was the new prohibition of pay secrecy clauses in employment contracts. If you're a lawyer or a HR representative, you'll know that including a confidentiality clause or pay secrecy clause in an employment contract has been standard practice. I mean, I know that I've never had a reason to advise a client not to include these types of clauses in an employment contract. But now, thanks to this new Act, these types of clauses are invalid. So what will now happen is, well, for new contracts entered into from the 7th of December 2022, any pay secrecy clause that is still included in the employment agreement will be invalid. But if those clauses still appear in a new employment agreement after 7 June 2023, then employers can face a penalty. And this could be as much as 60 penalty units, which is about currently $16,500, or it could be 600 penalty units for a serious contravention, and that's about $165,000. So we need to remove these clauses. I was actually talking to a client just last week who said to me that it's the beginning of the year. She wanted to bring her employees in to remind them of workplace policies, and part of that discussion, she wanted to talk to them about or remind them not to discuss their pay and working conditions with each other. And I had to say, hold on a second, stop right there. We now can't do that. Employers need to be really cautious about giving any type of direction to their employees that tries to stop them from talking about their pay and working conditions, because this is now what's been introduced in the Act in December. Having said that, for existing contracts that have been in place before the Act was introduced, so before 7 December 2022, the pay secrecy clause will still be valid in the contract until that contract is varied. But what I think will ultimately happen is, a variation to a contract can happen just by the employer increasing an employee's remuneration. And so particularly for a number of businesses that review their employees' remuneration each year, what I think we'll find is that that these pay secrecy clauses in existing employment agreements will stop to have any force, over the coming year or over the next couple of years. So, Dean, over to you. What do you think the implications will be of this new prohibition on pay secrecy clauses for businesses, particularly in the private sector?
Yeah, thanks, Anika. Look, I think employers that ignore this are going to end up in turmoil and have a lot of workplace resentment. I think employers have got to get ahead of this to avoid problems. That would mean doing comparisons across existing pay rates and job descriptions. Are they right? Check internally. Are there gender pay gaps? Are there anomalies? Are there long-term employees that are being paid too much, for example? Benchmark externally, get information and figure out whether there are going to be problems with pay disparity. Anika, what should employers do to ensure compliance with the new changes?
Well, the first thing immediately is for all employers to update their employment agreement templates to remove these pay secrecy or confidentiality clauses. If anyone wants us to review their existing employment agreements or provide you with a new template to make sure that this isn't included, please feel free to reach out to us and we can contact you about that. But it's not just the implications from a legal nature, removing the clause. There's also implications at an organisational level where now there's going to be this a lot more pay transparency in the workplace, and effectively employees now have this positive right to disclose their remuneration to other co-workers if they want to. So, Dean, what do you think our workplaces should do at an operational level?
Yeah, so I think employees are going to be asking some hard questions. I think employers have to be prepared for that. In pay reviews, it's why is Bob or Betty, they're lazy, they're late to work. Why are they getting paid more than me? So there'll have to be some thought around these sort of answers. Why is your sister's son being paid more than me? So I think there has to be some consistent communication with employees. You can't tell one employee one story about pay rises and another employee a different story. You're going to get found out. Then the question, do you normalise? Do you pay all account clerks the same amount, or do you differentiate? Do you still pay based on merit, on longevity, on loyalty? But employers have to take these things into account, give this some thought. If you get it wrong, there will be reputational problems, there'll be morale problems, and there'll be employees feeling undervalued.
That's right. I think Dean's covered some of the things that employers should do to respond to this new law, but in case anyone is looking back over these slides later, we have included some points here about some suggested employer action that they can take just to respond either from a legal perspective, but also at an operational level now that pay transparency is going to become a lot bigger in the workplace. So before I continue on, does any of our listeners have any questions they want answered on this topic?
Oh, we do have a good question from Craig. Thanks, Craig. Does the pay secrecy clause apply to executive contracts? And I think the answer to that is that no, it only applies to contracts under that the salary cap, which I think is around 160 at the moment. So under the high employer salary cap, a high pay salary cap. So thanks for that question, Craig.
Okay. If there's any more questions, we might answer those ones towards the end of the webinar, but we'll move on now to our next topic, which is fixed term employment contracts. So what's changed here? Well, this is a change that's going to come into effect later this year in December 2023. And this change is that fixed term employment contracts now from that date may only be used for a role if the contract is for no longer than 2 years, or it's for 2 consecutive terms that are for no longer than 2 years combined. If those rules are breached, the expiry term in the contract will be invalid, and the employee will then be regarded as a permanent employee. All the other terms in the employment contract will still apply, but as a permanent employee, the worker will then get these additional entitlements to notice of termination, redundancy, and protections against unfair dismissal. In enacting this change to the Act, the government recognised that fixed term contracts can be used for genuine purposes, but when they're used for long periods or they're rolled over for extended periods, they can really undermine the employee's job security. In particular, they identified that there was more than half of workers that were employed on fixed term contracts were women, and about 40% of fixed term contracts have generally go for more than 2 years, or the employee's been with their employer for more than 2 years. So what the government is really trying to achieve with this change is really to move more employees into permanent employment. There are some exceptions for when fixed term contracts can still be used. So I've listed them on this slide here, but some of them are. So if you wanted to enter into a fixed term contract that's more than 2 years for an apprentice, or for an employee who earns above the high income threshold, which is currently $162,000. Also for certain government funded or positions that are wholly or partly funded by government, or a governance position that has a time limit to it. So there are some exceptions there. The next thing that employers need to be aware of if they do enter into fixed term employment contracts is that from December this year, they'll need to give those employees a fixed term contract information statement. And if they don't do that, they can be subject to penalties of either 60 penalty units or 600 penalty units for a serious contravention. So particularly employers need to make note here that if they are going to enter into those contracts after December, make sure you get the fixed term contract information statement. It will become available later this year, and give it to the employee around the time that you're giving them the employment contract. Dean, what do you think now employers should do to ensure compliance with these new laws about fixed term employment contracts?
Yeah, I think if there are any employers that want to keep rolling out these fixed term contracts, it's a matter of really understanding those exceptions and seeing if you fit within those exceptions, and then implement a strategy, and perhaps even get some employee sign off that they do fit within the exception, and move on from there.
Yeah, that's right. So I think as well, there's two things that need to happen. One at a legal level is, again, update your fixed term contracts templates. Make sure that you remove excessive renewal clauses that could that might have been there from previous ones. Also, more at an operational level is just think over the coming year, employers should be thinking about the composition of their workforce, and thinking, whether people that were previously employed on a fixed term employment contract can be moved over to a permanent position or a casual position, or really should that position be made available for a contractor. these on our next slide, these are just some suggested employer actions that we've just generally discussed. And I think the last one to add is, again, if you're using a fixed term employment contract based on an exception, so if the contract is for more than 2 years, but your business has an exception to use it, what I would be suggesting to my clients is to include a written acknowledgement in the fixed term contract, so that it's really clear that that contract is being entered into pursuant to an exception to the law. So if you'd like us to review any of your fixed term employment contract templates, again, feel free to contact us and we can help you with that. I'll now ask again, any listeners that have any questions on this topic, feel free to raise them, and we'll probably answer one or two now, and then towards at the end of the webinar we'll try to answer some more. No questions on this topic? Maybe we've covered it. All right, if anyone thinks of any other questions, feel free to ask them, but we'll move on to our next topic. And this is quite a big topic, actually, because what the new laws does, it makes really significant changes to the Act, to the enterprise bargaining framework in the Act. So at the moment, approximately 1/3 of employees in Australia are covered by enterprise agreements. I've recently read that there's about 11,000 existing enterprise agreements based on some data from September 2022. However, the use of enterprise agreements has been in long-term decline, and really, particularly for the private sector employers tend to prefer individual employment agreements that are underpinned by the awards, rather than going through what was generally a complex enterprise bargaining process. But now the Act is introducing changes that I think will be quite impactful to this enterprise bargaining regime. It will lead to greater bargaining power for employees and their bargaining representatives, result in more enterprise agreements being approved, and it may result in more employers being forced to engage with the enterprise bargaining process. And I think what the government is hoping to achieve here by amending or changing this framework for enterprise agreements is really to try to lift wage growth, because we already have award wages that set the minimum standards. But what enterprise agreements do is they need to provide employees with something where they're better off overall than what the award is. So by making this process of enterprise bargaining easier, the government here is just trying to get more employers and employees to engage with the process to try to boost conditions for employees. So because there are these changes that could be quite impactful, I do think that it is worthwhile for all businesses to be aware of these changes to the enterprise bargaining framework, even if those businesses haven't utilised enterprise agreements in the past. It may now, more employers may find that they're roped into the process, and it's good to just know that there's these other options available. So some of the changes that we'll be drawing attention to coming up is the changes to multi-enterprise bargaining, which could result in more employers being compelled to bargain together. Changes that will make single enterprise bargaining easier to be initiated by employees. Changes to the way that the better off overall test is applied to the approval process for enterprise agreements, and also the broader powers that the Fair Work Commission has to determine bargaining disputes. So firstly, on multi-enterprise bargaining, there's been a massive overhaul of this. So multi-enterprise bargaining is where 2 or more employers can join together to bargain to make an enterprise agreement for their employees. What we're now going to have is 3 streams of multi-enterprise bargaining, which are single interest bargaining stream, the supported bargaining stream, and the cooperative workplaces bargaining stream. I'm just mainly going to talk about the single interest bargaining stream, because I think that is going to be the one that's most relevant to our listeners today. So I'll talk about Great. So what this single interest bargaining stream is, it's where two or more employers can bargain together for an enterprise agreement where the employers have clearly identifiable common interests. There's also a few other requirements there that will need to be met. So what common interest employers are employers whose operations and big business activities are reasonably comparable, having regard to the nature of their enterprise, the terms and conditions within those enterprises that are currently offered to their employees, the geographical location, and whether they're subject to a common regulatory regime. So what will now happen? So the other important feature of this single interest bargaining stream is that now employee bargaining representatives will be able to instigate the process for the bargaining process for an enterprise agreement for their employees. So this is different to what was happening before, because previously a multi-enterprise agreement like this could only be made in more limited circumstances, and it had to be more at the initiative of the employer. But now I guess the balance of power is changing, and it could be that bargaining representatives like unions get the employees together to come to an employer to say that they want to join with another employer for this multi-enterprise bargaining agreement. In order for that to happen, there has to be, a majority of the employees need to approve, and the employer has to have more than 20 employees. That there is an exclusion for the construction industry. They won't be subject to this. So, Dean, what do you think these implications will be for employers with these changes that will now seem to make multi-enterprise agreements easier?
Yeah, thanks. So, what's going to be interesting is that employers, particularly some small employers with 20 plus employees, are going to be subject to determinations and enterprise bargains that they have had no input in. They've been, if you like, dragged along by a larger organisation under these grouping provisions. So, that will disempower some smaller employers. Then there is the question of whether a business that employs 20 people does have commonality with a business in a similar industry with 2,000 people, or a multinational. But this is the territory we're getting into. Which of these smaller businesses are going to be dragged along and have to accept enterprise bargaining agreements that were negotiated by much larger organisations with different margins, different labour costing mechanisms and schemes. So that will be interesting to see how that plays out.
Yeah, it seemed like that all of these changes, it's there to make enterprise bargaining more accessible. And as I said before, it's really to try to, what the government's trying to do is all those employees that may be getting award, that may be covered by an award, they're trying to, move them into more of an enterprise agreement potentially, so that they're getting some better working conditions under that agreement. So it'll be interesting to see how this one plays out over the next year or two. So the next change that I think will have some impact in the enterprise bargaining framework is the change that now reduces the barrier to initiate bargaining for an enterprise agreement. So what can now happen is that the employee bargaining representative can give the employer a written notice to bargain if these certain conditions are met, including if the proposed agreement will replace another existing enterprise agreement. So this is for single enterprise bargaining. So it's between one employer and another, and its employees, or the employee bargaining representative. So yeah, what will happen now is that rather than the employee bargaining representative have to jump through a few hoops in order to instigate the process again, it'll be a bit easier for that to do that. I mainly think this change really affects those employers who are trying to phase out an enterprise agreement. But what they could find is that because it's easier for the bargaining representative to bring them back into the process, it'll just be more difficult to phase one out and stop bargaining. So the next change overall to this enterprise bargaining framework is changes to the way that the better off overall test will be applied. As many will know, before an enterprise agreement can be approved, it needs to pass a better off overall test, and the Fair Work Commission does an assessment of that. What's now happened is that the Act's been amended so that the better off overall test is now based on a global assessment of the proposed terms rather than a line-by-line assessment of the entitlements between the enterprise agreement in comparison with the award. The Commission now needs to consider the patterns or kinds of work or types of employment that are reasonably foreseeable that are specific to the enterprise that the agreement relates to. That just improves what was happening previously under the existing test, which sometimes resulted in the Commission having to consider hypothetical matters. In addition to undertaking its own assessment, the Commission also now needs to consider the views of the parties. So if both the employer and the bargaining representatives agree that the better off overall test has been passed, the Commission should be giving priority to that view. The Commission will also have power to directly amend a proposed enterprise agreement if that's necessary to address any concern that it doesn't meet the better off overall test. What was happening previously is that employers were having to give undertakings about changes, but now ultimately the Commission will have this power to just make the change. Really, the changes are aimed at providing some greater clarity to employers about how the test will be applied, and also safeguarding the minimum employment entitlements of the employees. The last change to the enterprise bargaining framework, well, one of the significant ones anyway, is the changes now to bargaining disputes. What will now happen is that the Commission will have greater powers to resolve the dispute by issuing an intractable bargaining declaration. This is a declaration that can be made on the application of a single bargaining representative for a single enterprise agreement if the Commission is satisfied it has no reasonable prospects of the parties reaching an agreement. What was happening previously was that the Commission could only make determinations if there'd been serious and sustained contravention of bargaining orders, but now an intractable bargaining declaration will be able to be made by the Commission if it satisfies a number of conditions, including if the parties have been bargaining for 9 months or at least 9 months has lapsed since the agreement expired, and there's doesn't seem like there's any prospect of the parties reaching agreement. So if an intractable bargaining declaration is made, the Commission may provide the parties with a further period to negotiate, but ultimately the Commission can then make a determination to resolve the dispute. So Dean, how do you think that these changes in particular to the intractable bargaining declaration process will affect enterprise agreements?
Yeah, look, I think the path for the disputes to be determined by the Fair Work Commission has certainly opened up. So that's going to make having a determination of a bargaining dispute a lot more readily available. And I think that people will follow that path to the Fair Work Commission. That may not be a problematic thing for employers in that some employers, if they get into a dispute and can't resolve it on suitable terms, may roll the dice and see what outcome they get from the Fair Work Commission. Perhaps they'll end up with a better outcome than the bargaining process.
I think that what everyone is expecting from these changes is that there's going to be increased activity now in the enterprise bargaining process. I feel that the unions in particular are going to have a lot more influence in the process. And yeah, it'll be interesting, I think, to see how employers are affected by this, whether it helps or whether it doesn't, whether the power's been swayed too far, over the next coming year or two as these changes start to take effect. So if any of our listeners have any questions on this topic, we might choose one or two and otherwise answer any at the end.
Yeah, look, we've got a good question. Questions here. Yeah, so Emily asked a question in terms of what types of employers will be grouped together. And, one of the, in the commentary to the legislation, one of the, common groups that are going to be together are, franchise groups. So in a franchise group, you certainly have that commonality of business, and we're certainly going to have employers in a franchise group potentially grouped together for this purpose.
I think, yeah, I mean, it might depend at that operational level, like how comparable the two businesses are. I would think that also, within an industry, more employers will potentially be grouped together. I think that there is, with this new legislation as well, a bit of a push towards more enterprise bargaining in the aged care and childcare industries in particular. So yeah, that.
I think as employers get forced into enterprise bargaining, unfortunately, there are probably going to be more industrial disputes. So I think employers will have to, really brush up on their bargaining techniques and figure out an approach in this sort of brave new world.
If we have any other questions, or we'll wait to answer any more at the end. I'll just move on to our next topic now, another change that's come from the Act, which is in relation to flexible work requests. So as many of you may already know, if you are in the HR industry, certain eligible employees are able to request flexible work arrangements. But now the change that's being introduced is that from the 6th of June 2023, the categories of people that can ask and make these requests for flexible work arrangements will be expanded to include people that are experiencing family or domestic violence and pregnant women as well. So you'll see on this slide the categories of people generally, and at the end of the new categories that are being now added. Also, in relation to flexible work requests, the Act will put new obligations on employers before they can refuse a request. So now what will need to happen is that employers will be required to discuss the request with the employee. They'll need to make a genuine effort to find alternative arrangements to accommodate the employee's circumstances. They'll have to consider the consequences of refusal for the employee, and they'll need to provide a written response within 21 days of the request. And what that response then needs to contain is a specific explanation of the reasonable business grounds that the employer is using for refusing the request. The response will also need to inform the employee about the avenues for referring the dispute to the Fair Work Commission. So the reasonable business grounds for refusing a request haven't changed. They are still that it would be costly for the employer. There's no capacity to change the working conditions of other employees to accommodate the request. It's impractical, or it would lead to a loss of productivity. So that there are now, the employers will need to effectively go to more effort if they want to refuse the request. The Fair Work Commission will also have additional powers to conciliate and arbitrate any flexible work arrangement disputes. So what we may see is that if an employer does refuse a request, an employee may bring an application to the Fair Work Commission, or if the employer doesn't respond within 21 days, an employee may bring an application to the Fair Work Commission as well. Now, similar to this new regime of how we need to respond to flexible work requests, there's also a new regime for responding to an extended unpaid parental leave request. So currently, all employees are entitled to a minimum of 12 months of unpaid parental leave, and that can potentially be extended to a total period of 24 months. But what will now have to happen is if an employee makes a request to extend their parental leave after that 12-month period, again, the employer will need to respond within 21 days. They'll need to consult with the employee about the request and attempt to reach an agreement. And if the employer refuses the request, potentially the employee could make an application with the Fair Work Commission, and the Commission will now have powers to deal with that type of dispute. So Dean, can you tell us what should employers do when a flexible work request or a request to extend unpaid parental leave is made?
Yeah, look, I think in the past, these requests were sometimes ignored, or employers were looking for a way to refuse them. But look, I think now they're going to have to be taken seriously. Employers should be considering what reasonable business grounds they have for refusing. There'll have to be consultation with employees looking for alternatives. Now that the Fair Work Commission can review these decisions, what the employee does in terms of documenting the decision could be carefully scrutinised at a later time. So, this is going to have to be all the I's dotted and T's crossed.
I think as well, again, at an operational level, and what employers should be looking at doing now or implementing over this year is to just revise their workplace policies and practices about what should happen when these requests are made, so that there is a clear guideline for managers, in what they need to do to respond, so that the employee doesn't get dragged into any fair work applications potentially if there has been a refusal.
I think it's about having a really good process and following that process, and also employers will have to sort of deal with this change and this loosening of, or ability for employees to request flexible work arrangements post-COVID, at the same time as dealing with hybrid work practices and when are employees in the office, when are they face-to-face. So all of these things will sort of all get thrown into the same basket.
I just wanted to pop in, guys. We've had so many questions coming through, which is fantastic. I just wanted to let everyone know that anyone that's getting an answer to that, because it's coming from me, it's actually coming from Matthew, who is a workplace law expert. It's not me just giving my advice. So be patient with us, that we're answering them as fast as we can.
Thanks. We'll try to answer some online for everyone to hear at the end of this webinar as well. Look, for anyone looking back at these slides as well after today, we've set out here just some general steps that an employer could do when a flexible work request is made, or a request for extended unpaid parental leave. So in particular, diarise that 21-day period for the time limit to respond, consult with the employee, make the decision, and make sure that you put any refusal is written in a properly documented way that is compliant with the Act. So our final topic today, we're going to talk about the prohibition of sexual harassment in the workplace. So as part of the government's commitment to implement reform in this area, which has come about after the Respect at Work Sexual Harassment National Inquiry Report was released back in 2020, The Fair Work Act has now been amended to include a prohibition on sexual harassment in connection with work. The individuals that will benefit from this change will be not only existing employees, but it's also extended to contractors, work experience students, volunteers, and future workers. So that there's also going to be increased liability for employers in relation to sexual harassment in the workplace. So if the employer doesn't prove that they took reasonable steps to prevent the sexual harassment from occurring, they could also be subject to a claim, which could potentially lead to compensation having to be paid to the victim. So whilst this provision is new to the Fair Work Act, these are laws that already exist, and this liability already exists in the Sex Discrimination Act. But what is now happening, that by including it in the Fair Work Act, the Fair Work Commission is now going to have power to deal with these disputes. And what this and what the Amendment Act does is effectively establish a new dispute resolution framework to allow Fair Work Commission to deal with sexual harassment disputes. This will be handled firstly through conciliation or mediation, but then if both parties do agree, the Commission could even arbitrate the dispute, and that could even lead to a compensation order. These are powers that are now in addition to the existing powers that the Commission has to order a stop sexual harassment order. And these changes are all coming into effect from the 6th of March 2023. So Dean, now that victims will have this added option of making a complaint to Fair Work about sexual harassment, what do you think the implications will be for employers?
Look, I think Fair Work are going to be, they should be ready for a lot of claims. I think employees will see Fair Work as a very user-friendly place to bring these claims. I think there's going to be a rush of claims unless employers can put in place some measures to stop this sort of activity. So, another thing that I think is going to increase the propensity for claims is that there can be joint claims under the changes. So, where victims can join together, I think that's going to promote claims where they can be brought by a union representative on behalf of an employee. I think that's going to promote claims.
So in terms of what employers should be doing now to just effectively respond to this to this new law is, I think they should be looking at their current processes and their current policies, making sure that their policies apply not only to their existing employees but also to contractors and others, and making sure there's a clear investigative process internally if a sexual harassment complaint is made, so that it can potentially be looked at that workplace level before we get to a potential Fair Work Commission application.
I think employers, should try and promote a speak up culture. Have someone that is identified as the person that grievances can be taken to, have a grievance procedure, and also have some targeted training. Have some role playing, because make it absolutely clear what is unwarranted behaviour in the workplace, and inform employees of the implications of sexual harassment, what that means, how it will not be tolerated by the employer.
Absolutely. I mean, even just, with that speak up type of culture, managers in meetings just asking employees if they're having any problems and just giving that opportunity to raise any issue with them could help. Because, from an employer's point of view, the sooner that the offending conduct is identified, the sooner it can be stopped. So Yeah, there's some important changes there. So on our next slide, again, we have some suggested employer action and what they can do to respond to this change, which our listeners can go through later if they want to refer back to the slides. So finally, there are a whole lot of other changes that have been brought in from the Act. So we won't have time to go through them today, but I've just listed a few of them there in case anyone is interested to go through them. As you would have seen as well through our discussion, certain changes have staggered commencement times. So some changes have already come into effect in December 2022, but some will come into effect in March, some in June, and some in December this year. So at the end of the webinar, we will be emailing links to the Fair Work Commission and Fair Work Ombudsman websites, because they have some really useful tables there with the key dates for when each of these changes will come into effect, just in case anyone is interested.
Anika, we do have a couple of questions on that topic, which we might want to just cover off on. Thanks, Donna. She said, what are the things employers can do to prevent sexual harassment above just training and awareness? And I think, Donna, the answer is that Anika's just put up a slide that has all those extra things that can be done. So hopefully that answers your question. Thank you. We've got a question from Clarissa. Can these claims be retrospective?
No, actually. So the claims, if a claim is going to, so these changes are coming into effect in March, and the actual sexual harassment conduct can't be retrospective. It would need to have occurred after the law came in March. And then the employee can take action in relation to that conduct. Any more questions on that point? So we are going to conclude the discussion today, but we're going to hang around to answer some more questions. We would like to offer our listeners a complimentary offer of a review of your employment agreement templates. Or you're welcome to contact us for a complimentary 30-minute teleconference to discuss any employment-related matter. To take up this offer, you can either tick a box at the end of the webinar in the survey, and we'll contact you over the next couple of days. But I'm also happy to be contacted by phone or email if you have questions about this webinar or any other employment-related or commercial matter. And you're also welcome to connect with me on LinkedIn. So at WMD Law, here we work with many different small, medium and large businesses across multiple industries. We have a commercial law team, a litigation team, a property law team that works with our business clients. And we also have a family law team, estate team and criminal law team that works with our individual clients. We pride ourselves on our responsiveness to our clients and providing commercially focused advice. So we'd love for you to connect with our business pages as well on Facebook or LinkedIn. And now we'll go through some questions and we'll try to answer them. What have we got for questions?
Okay. Here's a question from Elijah. So, is there any concern that employees on fixed-term contracts will not be extended and replaced with a new fixed-term employee rather than be made permanent? Yeah, so I guess what Elijah is getting at is, does an employer avail itself of the 2-year requirement, then at the end of the 2 years recruit someone new for a period of 2 years? I mean, I suppose that's that's a possible problem, but but again, that would involve another recruitment process, and I guess there's a benefit to the 2-year employee, the knowledge that they have of the business, etc. But thanks Elijah for your question.
There are some anti-avoidance provisions in the Act as well in this section. So what employers can't do is have an employment, like a fixed term employment contract that does finish at the end of the 2 years, and then offer that same employee another fixed term employment contract if it's for substantially like a substantially or similar role or on similar terms. So there is some rules about that in the Act to prevent that from happening.
Yeah, Polo asks, does the 24-month unpaid parental extension apply to adopted children?
That's a good question.
We might need to come back to you on that. That's a very insightful question. Thank you, and we'll get back to you offline.
I would expect that it would, but I would want to double check the Act before responding to that.
Rebecca asks us whether we have recommendations or a resource for a good flexible work policy. Yes, we do, and again offline we'll send that to you, Rebecca. And thanks for your inquiry and for reaching out to us. Troy asks, in relation to the 2-year temporary contracts, if a person is backfilling a male or female employee that is taking parental leave as the primary caregiver under an EA for a 3-year period, is that an exception or work for the state government? So is this an exception where the purpose of extending the contract from 2 years to 3 years is to backfill for someone that's on parental leave?
I don't think that will be covered, actually. I mean, my thinking of these laws are, I mean, I think that there is I mean, the fixed term employment contract rules with the 2 years, I think that 2-year period was chosen for a reason, and that's the maximum time, you know, that an employee can effectively take unpaid parental leave. So what I think in relation to maternity leave roles is that employers are now going to need to probably look at entering into a fixed term contract for 1 year, which is the standard amount of time that most employees would take, and then potentially have that 1 year renewal. So it does give that employee the option of extending the parental leave, and the employer's kind of got this employee already lined up to continue on with the role during that time. Like, that's potentially what may need to happen there. But I think that in terms of then extending it further after the 2 years, I mean, what the legislation is saying is that employee really should be rolled into a permanent employee. They've been there too long. They've been there for more than 2 years at that point. The employer really needs to think about moving them into a permanent position.
Great. This is thank you to Lucy and Melissa also wanting us to share the flexible work policy with them, and we will do that. Thanks to Poppy for her question regarding flexible working. If a request for an employee is similar to another employee for flexible working, and the reason for the refusal is because it will impact the business having 2 employees with the same flexible work arrangement, in your opinion, is this a reasonable reason for the refusal, as it doesn't seem fair? It's first in, best dressed. I suppose, though, that you know, if for example an employee applies for flexible work arrangement to care for a child on a Friday afternoon, and that arrangement is put in place, you know, but then in an employment environment with 10 people, and then you have 5 other people request flexible working arrangements on a Friday afternoon. You know, I can see that that might not be possible. So, look, I think all of these questions and the answer to them, you know, just depend on the particular workplace and the particular circumstances.
I would say with that question too, that particular scenario, I mean, technically it is first in, best dressed, but what employers might do is, with offering a flexible work arrangement, it may be for a certain period, so it won't necessarily be indefinite. So there could also be like a trial period to see how it works. So particularly if one employee has requested it, there could be a trial period for that, to see if it works. And if other employees kind of pop their hand up during that time and say, hang on, we want flexible work requests too, the answer then may be, well, look, we've already agreed to this flexible work for this other employee and the business now can't accommodate, more at the moment, but there is this is an indefinite position, and we will endeavour to try to work towards some more equality between the employees, as it can be suited.
Yeah, look, I think we'll there are some other questions that are more specific, which is probably more appropriate for us to answer individually. But yeah, we'd like to thank everyone for your participation today.
Yeah, perfect. Thank you. And thank you so much,
everyone.
Anika and Dean, for all you've putting together. I know it was took quite a lot of time. We really appreciate it.
There is a lot of changes to go through, but important changes for employers to get their head around. So hopefully we presented it in an easy format so that our listeners can understand. And again, you're always welcome to call us or email us with any questions, or if you need any assistance with employment or commercial matters. Thanks.
Don't forget, if you'd like to take WMD Law up on their special offer to review your contracts, or have a teleconference, please don't forget to tick the box when you exit and answer the survey. But otherwise, we'll see you at our next webinar in a few weeks with the amazing Bill Borman. Thanks, everyone. Bye.
Thank you. Bye.